Everybody hear me?
Yes, Judge.
Yes, Your Honor.
All right. Oh, you're Mr. Torvet?
Mr. Tomish, Your Honor.
Tomish, that's right, Tomish. Thank you for coming in person. You did not need to, but I appreciate it. Okay. We will go on the record in the matter 24 CV 114. Larry Grayson et al. Versus Township of Sand Lake et al. Appearances are, we have appearing for the plaintiffs, Isaac Huddle, who is appearing by video conferencing. We have also by video conferencing appearing for defendant Township of Menon, Jerry Lynn Jacobs, and we have Zachary Tomish appearing for the defendant Township of Sand Lake. We're set today in this matter based upon motions filed. We had defendant Menon's motion for summary judgment, and we had defendant Township of Sand Lake's motion for summary judgment, and various responses to each. Well, not to each. No one responded to yours. So basic responses to Town of Menon's and non-response to Township of Sand Lake. So that is overwhelmingly convincing of that decision. Okay, so I want to just start with yours.
Sure. Thank you, Your Honor. The Town of Sand Lake moved for summary judgment seeking dismissal of plaintiff's complaint for failure to comply with statutory requirements under WSStat 893.80 sub 1D. This statute is compliance with the statute rather is a condition precedent before suit may be brought. The statutory framework of the statute really has two key provisions. One is a notice of injury, or it's also known as the notice of circumstances. That's under 893.880 sub 1D sub A. And the second is the notice of claim, which is under sub B. The purposes of this motion is focused on the notice of circumstances prong. Under the notice of circumstances, that must be served on the municipality within 120 days after the accident occurs. The primary purpose is to allow the governmental immunity to promptly investigate the matter, to evaluate the claim that made or to evaluate the circumstances that may later give rise to a claim.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At first glance, this may sound like a routine procedural argument, but don't let that fool you. This entire case could be decided before anyone even debates who was actually at fault. The attorney is explaining a legal requirement that can completely determine whether a lawsuit survives, giving proper notice to a government entity within the time required by law. Miss that deadline, and even a potentially strong claim can collapse before it ever reaches a jury. As you watch, pay close attention to how both sides interpret these rules and how the judge evaluates them. Do you think courts should strictly enforce procedural deadlines, or should fairness sometimes outweigh technical legal requirements? Let's see where this courtroom battle leads.
However, if a potential claimant fails to give notice within 120 days, there is a narrow savings clause that allows for substantial compliance. Under that savings clause, the plaintiff bears the burden to demonstrate substantial compliance by proving with sufficient evidence two requirements. One is that the defendant municipality had actual notice of the claim, and secondly, that the defendant was not prejudiced by the plaintiff's failure to give formal notice within 120 days. The case law notes that actual notice is equivalent to actual knowledge. That requires the governmental entity to have knowledge about the events for which it may be liable, identity of the claimant, and notice of the specific relief sought. Supreme Court of Wisconsin and Maple Grove Country Club stated that if non-compliance with the notice of circumstances is raised as a defense and the plaintiff fails to demonstrate actual notice and lack of prejudice, then dismissal is required. So how does that apply in this case here? The accident giving rise to this lawsuit occurred on April 30th of 2022. 120 days after that date is August 28th. The record is clear that no notice of circumstances was served on Sand Lake in that time frame. The record is clear that either Mogen received notice within the 120 days. Plaintiffs do not dispute this fact. Thus, the analysis turns to the savings clause because actual notice was received outside of the 120-day time frame. As noted, the plaintiff here bears the burden to demonstrate that Sand Lake received actual notice and also that Sand Lake was not prejudiced by their failure to give formal notice. The record is clear here, Your Honor, that it wasn't until April 24th of 2024, nearly 2 years after the accident, that Sand Lake received actual notice. Any argument that the notice received by Mogen or Burnett County cannot be imputed to Sand Lake because the statute explicitly requires service upon the municipality. So all that's left is then prejudice. And in this case, the plaintiffs have failed to produce any evidence whatsoever on the issue of prejudice. There's been no affidavits, no testimony elicited in depositions, no discovery interrogatories. And it appears they inherently concede to the granting of this motion by not filing a brief in response to our motion. The plaintiffs bear the burden to demonstrate that Sand Lake was not prejudiced after their 2-year delay, and they failed to produce any such evidence. Therefore, the town of Sand Lake asks that the court grant our motion dismissing plaintiff's complaint for failure to comply with Stat 89380 sub 1D. Thank you.
Thank you. That was a very thorough motion that was filed and a very thorough argument on the motion. So I appreciate that. Neither or no other party, either Mogen or the plaintiffs, filed any response to Sand Lake. Therefore, based upon that alone, the court can default. However, I did review it thoroughly, and I will make my decision and factual findings on the record. That the plaintiff here failed to comply with the notice requirements under Wisconsin Statute 893. I can't even read my own notes. 0.80 paren 1D before the suit. The accident was on April 29th, 2022. The notice of claim to Sand Lake was on April 24th, 2024. Wisconsin Statute 893.80 paren 1D does go into the fact that within 120 days from the event, written notice of the circumstance by the party must be served to that municipality. Failure shall not bar action if you can show that Sand Lake had actual notice of the claim and the claimant can show satisfactorily that the delay or the failure to give notice does not prejudice that governmental agency. Sand Lake had actual notice on April 24th, 2024. Knowledge of the relevant facts of the event is not enough to qualify as the actual notice. You must have notice of the quote unquote claim, meaning that the specific relief that the plaintiff is seeking. And here, constructive notice does not qualify. Burnett County was served notice on August 14th, 2022, and the sheriff may have investigated. Sand Lake is not the county. It is a separate governmental entity, and therefore no notice was served upon Sand Lake. Any notice to Mogen is insufficient because they are, again, separate entities, and it cannot be imported to Sand Lake. Municipalities are not agencies of the counties. They are, again, separate entities, whereas they are distinct. They are incorporated to manage their own local affairs, while counties are primarily act as an administrative arm of the state government. They have independent authority. They are their own governing bodies, taxing authorities, police powers, and often exercise their own home rule powers that are not dependent upon county approval. Sand Lake was prejudiced by plaintiff's failure to show that plaintiffs failed to show that Sand Lake was not prejudiced. Plaintiff failed to show no prejudice, and plaintiff set forth no facts to show otherwise. Plaintiff could have asked multiple questions during Sand Lake's employees or people's depositions about prejudice. They did not. They could have asked whether there was difficulty finding the documents due to the delay or locating witnesses to the accident, etc., and they did not. A 2-year delay has severely prejudiced Sand Lake. Plaintiffs have had their forensic expert inspect the vehicle and extract data from it within 1 month. Sand Lake had no chance to conduct their own investigation or inspection, and no opportunity can exist now because the vehicle has been totaled and destroyed. So they are unable to investigate and evaluate the claims, and so it's unknown. Sand Lake only has the plaintiff's forensic expert report. And because they're not able to have their own, again, it shows severe prejudicial effects on Sand Lake.
That ruling is a major turning point in this case. Notice that the judge didn't dismiss Sand Lake because the underlying accident lacked merit. Rather, the decision centered on a procedural requirement. The court concluded that Sand Lake did not receive the legally required notice within the statutory deadline and that the plaintiff failed to prove the delay caused no prejudice. In civil litigation, procedural rules aren't mere technicalities. They exist to ensure every party has a fair opportunity to investigate and defend against a claim while evidence is still available. What do you think? Should missing a legal deadline be enough to end a case? Or should judges have more flexibility when the facts themselves deserve to be heard? Stay with us, because the courtroom isn't finished yet. The dispute over the remaining township is about to raise an entirely different legal question.
Based upon all of those facts and that information that the court has stated, the court does hereby find for Sand Lake and does grant the summary judgment. All right, let's move on to Menon. Ms. Jacobs.
The basis of my motion is that the Wisconsin statutes and relevant Department of Transportation mandates make it clear that the municipality with the responsibility for the roadway also bears responsibility for the installation and maintenance of the control signs along that portion of the roadway. Here, no one disputes that the town of Sand Lake bears responsibility for the road maintenance of the intersection at which the accident is alleged to have occurred, and for the portion of Lily Lake Inn Road that leads up to that intersection. What is disputed is that whether the municipality that bears responsibility for the road also bears responsibility for the traffic controls along that portion of the roadway. So the Wisconsin Manual on the Uniform Traffic Control Devices, Section 2C.35, makes it clear that the municipality that has jurisdiction of the roadway, and that's important, and I'll go into that in even more detail later, has the responsibility for the maintenance and installation of the stop signs that are placed along that roadway. WSStat 349.065, which provides that, in part, that local authorities shall place and maintain traffic control devices upon highways under their jurisdiction to regulate, warn, guide, and inform traffic. So this all comes up because there's a property line between the two municipalities. It goes down the middle of the road, and there's properties on one side, and then there's properties on the other. So it makes sense to divide the property line between the two towns down the middle of the road. But for roadway responsibilities, that doesn't make sense. It doesn't make sense to have the left hand or the southbound controlled by one, the northbound controlled by other. So our state legislature and our Department of Transportation have divvied up all the roads, all the municipal roads, county roads, and makes one or other bear responsibility for it. Here, if the provision had said just whichever municipality has jurisdiction, then there might be an argument as to whether that means of the roadway or of the geographic boundaries. But here it's very clear. You have to look at it in context and note that it says jurisdiction of the roadways. And by that, the clear, reasonable person would understand that to mean that if you have that, it means the roadway and not the geographic boundaries of the town. Again, this occurs because the DOT sets out that responsibility for roadways, you receive the funding for it. And then there's no dispute that Sand Lake is responsible for the roadway. If the manual meant, if the Department of Transportation meant that it was to extend to the municipality's property lines, then the provision would not say jurisdiction of the roadway. It would have said something else. And it wouldn't need to have qualified it as being over the roadway. And the opposing parties had some language that about the vagueness of the word jurisdiction. And I want to just set out that courts are to examine the ordinary meaning of a term when it is not defined within the particular statute or provision. And here the ordinary meaning of jurisdiction would be to officially have power over it. And here again, the Department of Transportation has set out that the town of Sand Lake has responsibility, supervisory authority over that portion of the roadway where the stop sign should have been. One can also look at what a recognized dictionary would say. And if you look at Merriam-Webster's online dictionary, it states that jurisdiction means the power or right to exercise authority. And here the entity that had the power or right to exercise authority over the traffic control signs is Sand Lake. You can see that we have the evidence that the caution sign that's a few yards before it is designated Sand Lake on the back with SL. Sand Lake at one point did, the evidence I believe shows that Sand Lake did take care of this at one point. And that responsibility just seems to have fallen back, or at least did not happen in this case. The clearest definition of jurisdiction in this context is that it meant over the roadway, because it says that, it qualifies it of the roadway. The opposing party, one of them cites a 1986 one-page handwritten contract. That contract is not authenticated. No evidence was offered that it hadn't been rescinded in the 40 years since it was implemented. There's no evidence offered that it's still valid and enforceable. Indeed, in plaintiff's own brief on page 5, it states, both Mogen and Sand Lake have snowplowed the intersection of Lily Lake Road and Austin Lake Road in the winter of 2021 and 2022. It simply depended on which municipality got to the intersection first. So this shows that the two municipalities have not been operating under that 1986 agreement for the relevant time period here. He also submitted an affidavit from the town chair of the town of Mogen, who says that he was not aware of this contract. They've not been abiding by it. At no point has Sand Lake ever said, look, there's this contract. You're supposed to be plowing up to here. And even if we consider the contract, even if we did not take issue with it not being authenticated, the fact is that this contract only outlined responsibility for snow plowing and sanding. It did not shift responsibility for maintenance. It did not intend to supersede the state statutes or the Department of Transportation manual. And Sand Lake has received the money for that portion of the roadway, going back as far. They have no evidence that they've not been receiving money for that. Plaintiff also cites that it would just be unfair if if this motion were granted. And there are requirements throughout. There is the notice of requirement. And the lack of not knowing that 893.80 existed would not allow a plaintiff to proceed. So here, if the plaintiff happens to make a mistake in suing the wrong town, that the investigation wasn't done at the time to determine whether there was an issue, a recognition that this was along a town boundary, maybe we should look into this. It doesn't then create new law that says, okay, even though the law says this was not town of Menon's responsibility, we'll make it because otherwise, you didn't happen to sue the entity that you should have done. Finally, the opposing parties fault the town of Meaden for not supporting a case to interpret this interpretation. I have two responses to that argument. The opposing parties themselves have cited no cases that dispute the town of Meaden's interpretation. And more importantly, this is just a straightforward issue. I've dealt with well, I can't bring in what I've done, but it's a straightforward issue. I've seen, it's understandable that no municipality would press the argument that that the Department of Transportation manual does not mean that they're responsible for the traffic control devices along the portion of the roadway that they are responsible for. So that is the basis of my motion, Your Honor.
All right, thank you. Let's go to plaintiff.
Thank you, Your Honor. I would agree with counsel for Menon here that this is a relatively straightforward legal inquiry here. And there are a number of key facts here that aren't really in dispute. This is a town line highway that's divided right down the middle. Lily Lake Inn Road on the western portion of it is Menon, and on the eastern portion is Sand Lake. There's no dispute here that the stop sign, the missing stop sign, was supposed to be located physically within the town of Menon. And the inquiry for the court then is just simply, is Menon supposed to be responsible for a stop sign located in Menon, or is Sand Lake supposed to be responsible for it because it's compensated by pay miles for taking care of this portion of the roadway? And I also don't disagree with counsel for Menon that the WMUTCD standard and WSStat 349.065 are applicable here. I just don't agree with the definition and their interpretation of the statute and the standard, because the state, for example, the WMUTCD standard states, and I'm just going to read the same standard, the unit of government who has jurisdiction of the through roadway shall be responsible
I'm
for
just
the
gonna,
installation.
sorry, can you just read it a little slower? My court reporter's fingers are going fast.
That's no problem, Your Honor. I can slow down. The WMUTCD standard provides that the unit of government who has jurisdiction of the through roadway shall be responsible for the installation and maintenance of the stop sign. And WSStat 349.065 provides that local authorities shall place and maintain traffic control devices upon highways under their jurisdiction to regulate, warn, guide, or inform traffic. Here, I mean, my dispute with counsel for Menon's interpretation of that is this statute and this standard don't define what it means to have jurisdiction of the through roadway. It doesn't provide that a municipality that receives compensation for maintaining the roadway therefore has jurisdiction of the roadway. And I think that's where turning to legislative sources discussing this exact issue is imperative for an understanding of what jurisdiction means. And I think if we took Menon's interpretation of 349.065 or the WMUTCD standard, I think statutes such as WSStat 82.21 would be rendered completely moot here. I think 82.21 presents the best discussion of this kind of issue. That statute discusses how municipalities are to handle town line highways. And I think there's a few notable subsections of the statute I just want to point out for the court, starting with subsection 1, initiating the procedure. And it provides that the procedure to lay out, alter, or discontinue a highway on the line between a town and another town, a city or a village, or a highway extending from one town into an adjoining town, city, or village, shall begin only when one of the following occurs in each affected municipality. And the statute goes on to demonstrate how town boards or city councils or village boards are to introduce a resolution to address this problem. Subsection 4 of 82.21 provides that a highway order issued by two towns or by a town and a city or village may designate the part of the highway that each shall construct and repair and pay the damages for, if any, as to the portion of the highway that the town, city, or village agrees to construct, keep, and repair and pay damages for. The town, city, or village shall have all of the authority and be subject to all of the responsibility in relation to that part of the highway as if that part were wholly located in the town, city, or village. I think that last portion of that statute that I read there is imperative here because that indicates that the geographical boundary of the municipality is important when we're considering what jurisdiction means. And I don't think that the legislature would have put forth this kind of statute if a plat map designating pay miles for snow plowing was indicative or dispositive on the issue of jurisdiction. And frankly, I think that here Sand Lake and Meenen had an intersection that both had been taken care of. There's evidence from both Meenen and Sand Lake that they had both taken care of the intersection. I don't think one sign with SL on the back of it is dispositive on the issue that Sand Lake was therefore responsible for it or that it had been responsible for it for all of time, like Meenen suggests. And I think that this was the procedure that Meenen should have followed if it wanted to apportion its responsibility for a stop sign physically within its geographic boundary to Sand Lake. And even if, they weren't able to get a highway order across or an agreement with Sand Lake, subsection 5 of 82.21 gives even another remedy for them wherein they could petition the court to address a potential inequity. So I think to any extent that the argument is that it wouldn't be fair, it would be illogical for Sand Lake to be compensated for the pay miles because it's inequitable and it could lead to poor results for different municipalities down the road. There's a statutory requirement under 82.21, and there's various remedies under that statutory mechanism that Meenen could have followed and didn't follow. The record's very clear. There's no highway order, no agreement between the two municipalities. And I think, I cited a handful of other statutory mechanisms in a case that aren't on point for the stop sign issue, but they do discuss how jurisdiction for a municipality is based on the geographical boundary of the municipality. I cited WISStat 66.0105, which discusses how it actually bars a municipality from exercising jurisdiction, quote unquote, within the corporate limits of another city or village. And similarly, WISStat 62.237A AM2 provides that the only way a municipality can exercise authority outside of its jurisdiction is if there's an agreement between two municipalities. And I think that the court should rule that jurisdiction is based on the geographical boundary of Meenen. The stop sign or the missing stop sign should have been located physically within Meenen, and Meenen didn't follow the appropriate statutory mechanisms to apportion that responsibility to Sand Lake, which would have put Sand Lake and Meenen on notice of who was responsible for maintaining the stop sign. So I would respectfully request that the court deny Meenen's motion for summary judgment.
All right, Mr. Thomas.
Thank you, Your Honor. Before I begin, does the court still want argument given the position that my client is no longer in this case, given the...
Good points.
All right. Thank you, Your Honor. I think that there are two genuine issues of material fact that preclude granting Meenen's summary judgment motion. The first one is how Lily Lake Inn Road came to be in existence, because Wisconsin law treats highways differently depending on how they came into existence, and because of depending on how they came into existence has a hand in the jurisdiction of who's responsible for that highway. In this case, a jury would have to determine whether Lily Lake Inn Road was laid out pursuant to statute, or rather...
Well, I'm going to interrupt you there because I don't buy that argument. I've already been there, researched, did the things. Move on to the next one because I don't think that's a jury decision.
Sure.
I've already looked into that.
Yes, absolutely, Your Honor. Well, the second one is whether it has its user and origin. If it's determined that,
That one too. So next.
okay, the second issue then that a jury would have to decide that would preclude granting Meenan's motion is the maintenance of Lily Lake Inn Road between the township of Meenan and the township of Sand Lake. And in this case, given the facts from the representatives, Mr. O'Brien from the town of Meenan that testified that the town of Meenan has not serviced the south half of Lily Lake Inn Road since he has been in his respective position. That is contradicted by the town of Sand Lake's road maintenance supervisor, Mr. Brad Huser, that testified. Actually, it depends on which county gets there, or not county, which municipality gets there first. And he also testified that he has personally observed Meenan plow the intersection of Austin Lake Road and Lily Lake Inn Road in the winter of 21-22, which is the winter that preceded this accident. And I would argue that snow plowing is equivalent to maintenance of a roadway. I don't think there's a distinction between taking care of the physical road and signage. I think it goes hand in hand. And I think that for those reasons, it's left to a jury to determine a factual dispute as to which municipality had responsibility over this intersection when there's competing factual disputes.
Thank you. I just wanted to hear those things on the record. All right, rebuttal, Ms. Jacobs.
Yes, WSStat 82, chapter 82 is not applicable here. WSStat 82, and I'll walk through it. WSStat 82.21 has to deal with the procedure for laying out, altering, or discontinuing a highway. And so this happens quite often. They probably come to you, you've probably seen some of these cases where if you want to make these changes, this is how you go about it. And for instance, number one, it says that yes, one town can agree to another. Right now, the responsibilities are laid out. We have the plat records. Every municipality has to sign off on it. There's no dispute here that the town of Meaden signs off on the northern portion of Lily Lake Road, and that the town of Sand Lake signs off on the southern portion of Lily Lake Road, the one that is at the intersection at which this accident is alleged to have occurred is. Now, as to number 4, the appeal of apportionment, it says there are 2 sentences to this, and plaintiff is looking at the second one. The municipality shall, the municipality shall, I can pull it up again. That as portion of the highway, that they agree to construct, that they agree to repair or pay damages on it. Now, that's qualified by the first one, and that says if a highway order is issued between 2 towns. If 2 towns decide, look, why don't you be responsible for the whole part of this highway? And the plat changes then for the following year. If we're going to agree that, then that portion of the highway, you agree that you are going to also construct, repair, and pay damages on. And that means that the plat next year will come, that parentheses will come to a different point, and it will signify that suddenly that town is now responsible for the construction repair of that. That's what that means. That second sentence that plaintiff relies upon is wholly dependent on that first sentence, there being a highway order between 2 towns. And as counsel for Sand Lake has already noted, there is no highway order at issue here. That is wholly inapplicable. It's a red herring of an argument. All of 82 is a red herring of an argument. The number 1, the appeal of an apportionment. Again, that's if one doesn't like it, they shall file an application. This whole procedure is if you want to change how things are as of today. That is why it is wholly applicable here. As to 66.0105 that council relied on, it says, unless otherwise agreed to by the town, a city or village cannot, which is this the authority of a city or village to exercise jurisdiction, and that does say city or village, it does not say town, I will note, and those are different entities, can, with different legal formations. Cities and villages are very much alike, towns are very different, as I have learned. But in any event, regardless, it says that a town is not to exceed authority outside of its corporate limits when exercising or acting under 3 certain sections. Under 66.0401, which has to deal with offensive industry, unless it acts under 236.10, which has to deal with approvals necessary for plat approval, or unless it deals with 254.57, which is smoking emissions. So 66 is not triggered here. In fact, if you read 66, it makes the same sense in that it is saying when an entity can exercise jurisdiction, just as the provisions regarding the highways that I depend on, and just as the manual says, it is defining the jurisdiction. And again, both parties, neither one of them is recognizing that it says jurisdiction over the roadway or jurisdiction of the through roadway. That's the important point here. That's why the manual matters, because it's not saying jurisdiction within the jurisdiction of the town. It is saying jurisdiction of the roadway. So the same, the other provision 62.23, not applicable here. They're red herrings. They are dealing with jurisdiction in certain instances, and I can look at that if you give me a minute, and I can separate that out as well. But those are all red herrings. As to there being an issue of fact, really that what has to be resolved is the meaning of jurisdiction of the roadway, and that's an issue of law for the court to decide.
All right. Thank you. I have thoroughly read all of the documents that have been filed, watched the little computer stick thing, read the cases that I may not have been so familiar with in the filings. So now I'm going to state on the record my take from everything, as well as then my decision. Defendant Menon's motion for summary judgment. Menon argues that the Department of Transportation mandates municipalities with responsibility for roadways. Also, they have responsibility for the signs. They say that it's undisputed that Sand Lake is responsible for the maintenance of entire Lily Lake Road. For as long as anyone can remember, Sand Lake has put up that sign at the T on Lily Lake that Sand will argue only responsibility for the maintenance, not the signs. The stop sign was missing for approximately 3 weeks before April 30th, 2022. Sand Lake received federal money to maintain the entire Lily Lake Road. The plat map marking the road portions with municipalities start and stop the responsibility. The plat shows Menon responsibility ends halfway down to the intersection with Austin. That the Department of Transportation town plat shows Sand Lake is responsible for that portion of the Lily Lake Road. Menon says Sand Lake will say only for road maintenance, but the Department of Transportation directive says maintenance, then responsibility for signs as well. WSDOT principles govern traffic control devices, and they provide whoever has jurisdiction through the roadway is responsible for the stop sign placed on the roadway at the approach to the through road. WMUTD standard really means mandatory. Wisconsin 349.065 says Sand Lake would be responsible. Authorities maintain devices upon highways under their jurisdiction. If the municipality controls the highway, it is responsible for the sign. Menon also says that where the accident occurred was Sand Lake responsibility. Menon says it doesn't make sense to have one entity responsible for maintenance and another entity for the signs. That Sand Lake has always taken care of the signs on that portion of Lily Lake. Menon didn't originally install that sign. And Menon also says there is a long-standing understanding of Menon that Sand Lake always put up that sign. Plaintiff's arguments contrary to Menon's motion for summary judgment argues that no order or agreement has been in place between Sand and Menon that says Sand Lake is responsible, not Menon. The portion of Lily Lake is in Menon Township. The sign was down and the officer was contacted Menon as of April 15th, 2022. And he spoke to O'Brien. I'm not using the full things here, just so everybody knows. I think that's fine because y'all know who I'm talking about. O'Brien told the officer the sign was down 3 months prior to April 15th, 2022. O'Brien took no steps to ensure the sign was put up, didn't contact Sand Lake, and didn't put up a sign. Sand Lake was notified 5 days before the accident and immediately replaced that sign. Sand Lake replaced it anyway, even though it wasn't their responsibility. The sign is located in Menon Township. Both Sand Lake and Menon are responsible or were responsible for the snow removal and did participate in the snow removal for 2021 and 2022. It was on a whatever municipality got there first basis. Both townships mowed the grass on both sides. Again, whoever got there first basis. There's a disputed fact as to whether Sand Lake or Menon mutually maintained that intersection. There is no agreement or highway order between Sand Lake and Menon for authority and responsibility of the maintenance. There's a different interpretation of jurisdiction and who it applies to in this case and in this set of circumstances. Menon has the burden to prove clearly the definition of jurisdiction. Menon has no case law to support that the sign in municipal limits, but other municipalities should be responsible for it, i.e. the sign in your municipality should be a sign you're responsible for. Jurisdiction is ambiguous. Plaintiffs argue that jurisdiction equals geographical boundary. Menon's jurisdiction runs through the center of Lily Lake Road. Wisconsin Statute 4.003, division of district may be center of street. Again, jurisdiction equals your boundaries. No agreement for the maintenance or responsibility given to the county highway commissioner or in the town map or in any of the town's filings. Notice needed so everyone knows if there is an agreement. There's a disputed or a genuine issue of material fact as to Menon or Sand Lake, who is actually responsible for the plowing and the mowing of that portion, because it is, according to everyone, whoever got there first. The court must look at the light most favorable. That means must look at that Menon maintained this area. Although Sand Lake installed the sign and it's gone, and they installed the next one, doesn't mean Menon never has or isn't responsible to do so. The sign is stamped SL on the back, but that's not evidence that Sand Lake always installed and always maintained the signs. Menon's jurisdiction plat map shows Menon's geographical boundaries. And Menon did not conclusively show that Sand has jurisdiction over the sign, a sign that is located within Menon geographical limits. Sand Lake's argument to Menon's motion is there are two issues of material fact, whether Lily Lake was laid out by statute or on the origin in user. Origin and user court, the court will not disturb the relations between Sand Lake and Menon with the maintenance. The statute legally laid out then divides between Menon and Sand Lake maintenance. There is no agreement that exists. A second disputed fact, which town bears responsibility for the south half of Lily Lake as it is demonstrated Menon maintenance did maintenance in 2021 and 2022. That absent, there is no agreement or highway order with Sand Lake and Menon. There's uncertainty on how the road is laid out. Menon's maintenance of the south half precludes Menon's motion. The record before the court is unclear whether Lily is laid out by statute or again, origin and user. There is that 1986 snowplow agreement, but it wasn't adhered to by either Sand Lake or Menon. Sand Lake argues that if the court were to go with the legally laid out or the origin and user, that it is issues for the jury to decide. There is nothing in the record to support an agreement, so it is a jury question, must decide apportionment and maintenance responsibility for that portion. Again, stated that Menon did maintain the road in 2021 and 2022 with snow removal and with mowing. That the 1986 agreement did establish that they were to alter snow removal on that portion every year. That Menon says they don't do snow removal there. Sand Lake says they've seen Menon remove snow there. Menon is responsible for the maintenance, means Menon is responsible for the sign. No highway order for this portion exists. Look at Wisconsin statute 82.21 paren 4. That is a question for the jury. Then the court did hear and read the reply from Menon as to Sand Lake, that Sand Lake doesn't dispute it, gets money for the maintenance, that Menon and O'Brien told the sheriff deputy that the sign is Sand Lake responsibility. He simply just believed the deputy would take care of it. I think that's the court's own note, I believe. That Sand replaced the sign before the accident, 5 days before. And then on the Thursday before, Sand Lake went back to check to make sure it was still there. It was. O'Brien says, essentially, not it. I told the sheriff. There's an undisputed fact that the sign was replaced between April 15th and April 30th of 2022, but it doesn't mean undisputed as to whose responsibility it is. So the court has essentially listed, not verbatim, an actual note taking as to all of the arguments, the statements made, and the positions of all parties in this matter. And I have heard the arguments. The court has again very thoroughly looked into this matter. The court finds that there are genuine issues of material fact. The court sees, was the sign removed at the time of the accident? The plaintiff says that, but I have Sand Lake saying that they checked on it the Thursday before and it wasn't, and it was there. Was there an agreement or no agreement between Menon and Sand Lake to maintain that portion beyond the 1986 agreement? It's alleged that neither township was working off of that agreement to alternate snow removal every other year. And despite as to who is responsible, there's a genuine issue of material fact. Is Menon or Sand Lake responsible for the maintenance? Plaintiff says, look at the light most favorable. And here it would be Menon. They're supposed to do the maintenance and be responsible for it. There is a genuine issue of material fact, as in whether or not Menon or Sand did maintenance, including snow removal and mowing, the year of 2021 to 2022. Menon says they don't do the snow removal there, but in 2021 and 2022, Sand Lake stated at a deposition that it was witnessed and that they saw Menon actually do the snow removal. Another issue, whether Menon did, in fact, inform the deputy that he believed Sand Lake was responsible. We have a statement from O'Brien, but that's it. Nothing else to confirm that. Nothing from the deputy. The court looked into jurisdiction. According to WISDOT Facilities Development Manual, Section 4-1-5.6, the responsibility for administering and maintaining local roads and streets in Wisconsin is vested in the towns and incorporated municipalities where they are located. WISDOT Facilities Developmental Manual 1.2 definitions. Jurisdiction is the authority and obligation to administer, control, construct, maintain, and operate a highway pursuant to applicable Wisconsin state statutes. Jurisdictional authority, the unit of government having jurisdiction of a public highway. Maintaining authority, generally understood to be the same as jurisdictional authority for the highway. Unit of government or level of government. The public road system is identified by the unit of government having assigned jurisdictional authority. Jurisdictional, there is no jurisdictional transfer here to see that there was any thing between Menon and Sand Lake as to transferring the responsibility for the maintenance and the sign. Wisconsin Statute 82.03 outlines the primary duties and authorities of town boards regarding the highways under their jurisdiction. Care and supervision, the town board has the mandatory care and supervision of all highways under the town's jurisdiction. In the Wisconsin Manual of Uniform Traffic Control Devices, jurisdiction refers to the specific authority and legal responsibility over the roadway and its traffic control devices. To administer, control, construct, maintain, and operate a highway pursuant to applicable Wisconsin state statutes. Under Wisconsin State Statute 349.065, local authorities are mandated to place and maintain traffic control devices on highways within their jurisdiction. Again, jurisdictional authority means the unit of government, which would be the state, the county, the municipality that has been assigned that legal responsibility for that public highway. Under the WMUTCD 1.6.4, maintaining authority and maintenance agreements. Maintaining authority, jurisdictional authority, and maintenance agreements get confused and are inappropriately interchanged. Maintaining authority should be considered the same as jurisdictional authority. A jurisdictional or maintaining authority can enter into a maintenance agreement with another unit of government to perform any manner of maintenance work or work on its system. These maintenance agreements are simply contracts to do work on the system and do not move jurisdictional or maintaining authority from one unit of government to another. As in here, when a road crosses multiple municipalities, the WISDOT Facilities Development Manual and associated Wisconsin statutes divide responsibility by the physical location of the road and the legal agreements between the entities. While the jurisdictional authority has the legal obligation to maintain the road, it again may enter into maintenance agreements with other units of government, other municipalities. However, again, these agreements do not transfer jurisdictional responsibility. The statute authorizes towns to enter into those contracts for the highway work and maintenance under Wisconsin Statute 82.03. Under the Wisconsin Manual on Uniform Traffic Control Devices and WISDOT standards, responsibility for a through street is tied to its legal jurisdiction. While the manual dictates how signs must look and be placed, the duty to maintain the road and its traffic devices falls on the agency that owns the roadway. Each municipality is responsible for the portion that lies within its specific boundaries. If a local road crosses from town A into town B, then town A manages the segment on its side of that line and town B manages its own. FDM, the manual 4-1-5.6 explicitly states responsibility for the administration of the maintenance of the town roads is vested in the municipality where it is located. Under Wisconsin Statute 82.21, it specifically addresses highways and bridges on a town or county boundary lines. It mandates that adjoining municipalities enter into agreements to divide the parts into maintenance and construction. It explicitly states they must enter into agreements to divide maintenance, construction, control, or nix the control. While control of and responsibility for both relate to authority, they differ in how the power is applied and what happens. Control of means the power to direct or restrain. Responsibility means focuses on the duty to take care of and the accountability. Therefore, the court, in its review of all of the Wisconsin statutes that are applicable, as well as the WISDOT manual, jurisdiction means within its geographical boundaries. The fact that Sand Lake may have gotten money for 18 years and has denied responsibility for the maintenance and the signs. It's not a not fair argument. Sometimes it's not fair. Mogen should have looked into whether or not it had a valid agreement with Sand Lake. Needs to be worked out because jurisdiction in the statute means the ownership within the geographical boundaries. So that is the court's ruling. I deny Mogen's motion for genuine issue or for a summary judgment because I do find multiple genuine issues of material fact. Sand Lake is dismissed from the matter. I have defined jurisdiction. There we go. Now let's look at the case. I'm not sure if we have a scheduling order, but if not, we have a proposed scheduling order. And we are beyond all of those dates. So what we're going to do is set a date and time now to have a further scheduling order. Can you do February 18th at 11 or February 20th at 9?
Either of those times work for the plaintiffs. Sorry.
Zoom's fine.
The 18th works for Mogen, works for me.
All right, so February 18th at 11, we will have a scheduling conference. Anything further?
No, Judge.
What an incredible legal battle from start to finish. This hearing demonstrates how courtroom cases often hinge on far more than the facts of the underlying accident. The judge ultimately reached two different conclusions. Sand Lake was dismissed because the plaintiff failed to satisfy Wisconsin's statutory notice requirements, while Menon's request for summary judgment was denied because the court found genuine issues of material fact that must be resolved before the case can move forward. In other words, one defendant exits the lawsuit on procedural grounds, while the remaining claims continue because important factual disputes still exist. It's a powerful reminder that timing, legal obligations, and procedural compliance can be just as decisive as the evidence itself. Do you agree with the judge's reasoning, or would you have ruled differently? Let us know your thoughts in the comments below. If you found this courtroom breakdown insightful, be sure to hit the like button, share this video with others who enjoy real courtroom cases, and subscribe for more in-depth legal analysis and jaw-dropping courtroom moments. Thanks for watching, and we'll see you in the next case.